You show me any case law.
Your Lordship, Supreme
अरे सुनना नहीं पूरी बात.
Your Lordship.
Lordship. बात समझना नहीं है बस. I mean, you people are overawed with Supreme Court judgments without understanding the facts of that case and the facts of your case.
Your Lordship.
We are talking of law and you are harping on Supreme Court judgment.
Section 3.
You need to understand the question first, then answer. Why are you so excited?
Your Lordship.
Show me a case law where the approval of the government is within 7 days. Still, Supreme Court has said that it has not been sent forthwith, therefore should be quashed. Show me a case law.
Your Lordship.
First to read the facts, whether approval was given within 7 days or not.
वो आप एनएसए का बताओगे आप.
हाँ वो
एनएसए वाला बताओगे आप.
हाँ ये इसमें NSA और all thing it has been considered और
नॉर्थ ईस्ट वाला.
Don't generalize the my lord's question.
Your Lordship.
Understand the question, then answer.
Your Lordship.
वो जो
And
आप
similar things.
बताना चाह रहे हैं वो एनएसए के रेफरेंस में.
नहीं वो प्रिवेंशन ब्लैक मार्केटिंग में भी इस न्यायालय द्वारा इसी जजमेंट को कंसीडर करते हुए
You please show us this proposition that
proposition.
despite there being an approval of the government within 7 days,
Your Lordship.
the Supreme Court has quashed that order because it was not forwarded according to you forthwith.
Your Lordship. In 2018 volume 9 Supreme Court cases.
2018
volume 9
volume 9.
Supreme Court cases. Page number 562.
Now first read the facts.
Your Lordship. Your Lordship. Fact is the appellant has been.
When was the order passed in that case?
Your Lordship. The order was passed in that case on 17/7/2017.
17.
12/7/2017, and it was communicated
12/7.
2017
हाँ.
and communicated to the state government on 17/7/2017. 5 days बाद.
And when was the endorsement done?
Endorsement, Your Lordship, on 12/7.
When did the government approve the order?
Your Lordship. Government has approved the order, Your Lordship, 17/7 on 5th day after passing the order of detention. 12.
Where is that written?
Your Lordship, it is in para 16. In the present case, the district magistrate submitted the report to the state government on 5th day, 17/7/2017, and after the date of detention, ordered 12/7/2017. The reason for delay of 5 days is neither mentioned in the state government order confirming the detention order nor in the impugned judgment, and it was for the district magistrate to establish that he has valid and justificable reason for submitting the report 5 days after passing the order of detention.
Okay.
And as the discussion is Joglekar holds the issues whether the report was sent to the earliest time possible or whether the delay in sending the report could have been avoided. Moreover, as the detention in Salim hold, there should be no laxity and reporting to detention to the government whether there were administrative exigency which justify the delay in sending the reports must be explained, and detaining authority in the present case we shall explain this was matter especially placed in issue before the High Court. The district magistrate offered no explanation. This would vitiate the order of detention, Your Lordship.
Now you show me when was the order or approval was passed.
17/7.
Show me that order.
Your Lordship.
Where is mentioned?
Your Lordship. They have filed the annexure.
No. In this case.
Approval was passed on 17/7, Your Lordship. 7.
Read that part.
In the present case, district magistrate submitted the report to the state government on 5th day 17/7 after the date of detention order 12/7/2017.
When did the government pass the order?
Seven. 20/7, Your Lordship. 20/7/2017.
20/7 हो गया ना. तो 20/7 is beyond 7 days.
हाँ उसमें भी भेजा. यहाँ तो भेजना 17 को है ना.
सवाल इसका है वहां पर 20/7 within 1 week government should endorse the order. That was endorsed beyond 7 days.
7 days. But endorsed beyond it. Even endorsement can be made up to the 12 days, Your Lordship. Issue is
where is that?
Your Lordship, the forthwith must be communicated to the state government.
First, let us understand where is written.
Your Lordship.
पढ़िए.
when subsection 3 of 3, when any order is made under this section by an officer mentioned in subsection 2, he shall be forthwith report to the fact to the state government to which he is subordinate together with the grounds on which the order has been made and such other particular as in his opinion have a bearing on the matter, and no such order shall remain in force for more than 12 days after making thereof, unless in the meantime it has been approved by the state government. Your Lordship. So forthwith it has been.
So therefore, and no such order shall remain in force for more than 12 days
12 days for the government. Your Lordship.
after making thereof, unless in the meantime it has been approved by the state government.
For the government.
Within 12. अब आगे पढ़िए.
But
Provided
whether any, under section 8 on the ground of detention are communicated by the authority making the order 5 days but not later than 10 days from the date of detention, this subsection shall apply subject to modification that words 12 days with the word 15 days shall be substituted. So for the government, up to the 15 days, Your Lordship, that approval can be made. But in respect to sending the order of detention to the state government, there should be forthwith. If the explanation it has not been given by the authority, why they have sent the order of detention on lapsing the 7 days, after lapsing the 7 days, Your Lordship.
all right. Anything else?
Your Lordship. So my respectful submission.
What is your next submission?
Your Lordship. And also in this regard, I am relying the two judgment of this honorable court.
Judgment will come later. First, show me the order, impugn order. How order is bad on other grounds?
Your Lordship, I have read, Your Lordship, the para 22 of the impugn order. Your Lordship. Firstly, my argument was mentioned in para 9.
That we have already said.
On the basis of
anything else, any other ground you have raised there?
Your Lordship, so many grounds I have raised before the detention.
It is not a grocery shop. You are arguing before division bench.
Your Lordship.
You have to crystallize your arguments. Don't generalize it. So many arguments I have raised. So we should dig out and find out which arguments have you raised. Thrice I have asked you this question. If you are not prepared, take time. You have to be crisp when you put forward your case. First argument we have understood. What about the second argument?
Your Lordship. Second argument is that, Your Lordship, in this matter, when Your Lordship petition was filed, at the pre-execution of the detention, Your Lordship, and during the pendency of petition, the petitioner has surrendered before the authority on 3/6/2022.
Order was passed on
10/7/2021.
12/7 आपने कहा ना?
10/8/2021.
10/8/21 हाँ,
और सरेंडर किया गया 3/6/22 को.
आपने सरेंडर किया.
हाँ, और उसके बाद मुझे ग्राउंड ऑफ डिटेंशन हैज बीन कम्युनिकेटेड टू द पिटिशनर ऑन 14/7/2022, जो कि 5 दिन के अंदर कम्युनिकेट होनी चाहिए.
If you are disappeared, who can help you?
Your Lordship,
if you have disappeared, then what can be done?
Your Lordship,
Absconding, that has come in the para 24.
absconding cannot be a ground of
3/6
अच्छा.
non-compliance of the
All right.
clause
All right.
8, Your Lordship.
Very
Clause
well.
8 specifically said in
Now
on the,
you tell me, when was the order of detention served upon you?
Your Lordship, clause 8 में kindly be section 8
I
of
think he
the,
is not prepared to argue.
Your Lordship,
Adjourn कर दो उसको. He is now ready with facts. I think he should be. देखिए, land council though initiated the arguments, but appears to be not well versed with the facts of the case. Hence, in the fitness of things, hearing is adjourned.
Your Lordship, any date because 6-month detention is already there.
You are causing damage to your client because your arguments are not on facts. You are more confident on law, which otherwise may not be applicable.
Even I come to the merits of the case, Your Lordship.
Because you have decided not to argue on facts.
No,
It appears.
I will argue on the merits of the also merits of the
Naturally, no case should be argued with law initially. Or case should be argued first on facts and then come on law. And you are arguing an appeal. You need to state the facts first. Now you come on the next date. Next week लगा दीजिए.
Next week.
Next week नहीं. इसको लगाइए आप, स्पेशल बेंच चाहिए तो
नेक्स्ट वीक ही
दिस विल कम ऑन टुडेज व्हाट
टुडे
11
18
18 को लगाइए इनका. You must know, you are a reasonably senior advocate, that once you start arguments, your argument first should state the facts. Then you pick up the law. But don't get overawed or excited with law. Law will take its own course. Unless we understand the facts, how can we apply the law? Your understanding of law may be defective if factual matrix is juxtaposition. Maybe.
I'll argue on
First, why you feel diffident arguing on facts? Facts are most important in a case.
yeah.
Unless you clear the facts, we cannot go for law.
I would like